Well, the general statement is no, they are not. But the bankruptcy code's wording is a little bit tricky. It says unless the non-dischargeability would create an undue hardship on the debtor and the debtor's dependents. So there is a slight open window there. Well, how does one exploit it? This is one of those rare times where a debtor will initiate a non-dischargeability action. Generally speaking, non-dischargeability actions are initiated by creditors who want the court to say that debt is not going to be discharged. But here, the debtor wants to get the court to say that debt will be discharged. So if the debtor doesn't initiate such an adversary proceeding, determination of dischargeability, then the debt is not going to be discharged. Now, this is a fairly high hurdle, and you might think, well, what's the big deal? You just have to show it's an undue hardship. How hard can that be? Very hard. There are a couple of things at work here. First, if you're a good candidate to get a student loan discharge, it's probably because you're in a Chapter 7 bankruptcy. And if you're in a Chapter 7 bankruptcy, you probably don't have a good source of funding to be able to fund whatever litigation is necessary, that is to hire an attorney. So a lot of the case law in student loan dischargeability actions involves pro se debtors, unrepresented debtors, and they're not really cut out to be able to go up against the counsel of the student lenders. So there is a fair amount of negative case law here against debtors. There is a test that was developed in a case called In re Bruner. That was a case from New York. And it is a three-part test that has been adopted by a lot of courts around the country, although there is of late some noise that maybe it's a bit too tough. It is, as I said, a three-part test. Here's the analysis. In order to get rid of the test, we have to ask, number one, if you have to pay it, can you maintain a minimal standard of living? And that's pretty minimal. Number two, will that situation persist over the entire repayment period? In other words, you're going to be living just absolutely like a bum. You just have no money to buy food or clothing or anything like that for the entire repayment period. And number three, you have to have already tried to make a good faith attempt at paying the debt. Well, if you're fresh out of school, the first one's probably a pretty easy one to make. You don't have a job yet. Well, maybe you do have a job, but a lot of people these days, they get out of school, they don't have a job yet. So can you maintain a minimal standard of living if you have to repay the debt? Well, no, not now. Don't have a job. It's the second one that's the really big hurdle. Will that circumstance persist over the entire repayment period? You just finished school. You're about ready to get a job that's going to pay a lot of money. Well, if you're going to get a job that's going to pay a lot of money, sorry, pal, it doesn't look like this is going to persist over the entire repayment period. And then, of course, did you make a good faith attempt at repaying the debt? There, you just have to show whatever your payment history was. So that's a tough one. There is talk in Congress of making student loans dischargeable in bankruptcy, but right now that's just talk. And every few years, somebody runs something up the flagpole saying, let's go ahead and make student loans dischargeable in bankruptcy. In fact, at one time in American history, they were dischargeable in bankruptcy. Then you had to have been making payments on them for 5 years before you could get them discharged. Then it was 7 years. And then in 2005, the rug was pulled out from under borrowers, and you just couldn't get rid of them unless you had the undue hardship. There have been cases where there's been a partial discharge of student debt. That is, you can get rid of some of the student debt, but not all of it. But that's really on a case-by-case basis, and it's up to the judge, who is the trier of fact, or the appellate forum if the case is appealed higher up. So at least right now, chances are you're not going to be able to get rid of student debts in bankruptcy.